Okay, good afternoon. My name is Ronaldo Hilton, the Chair Designee of the New York City Loft Board. Welcome to our July 19, 2018 public meeting. Section 282 of the New York State Multi-Dwelling Law establishes the New York City Loft Board. The board is charged with overseeing the conversion of interim multi-dwelling buildings from commercial and manufacturing spaces to safe, rent-regulated residences that comply with the minimum standards of safety and fire protection stated in Article 7B of the New York State Multi-Dwelling Law. To achieve this goal, the board adjudicates and mediates disputes between owners and tenants, tracks the progress of each building undergoing legalization, and prosecutes parties who violate the Loft Law and the Loft Board's rules. We will first turn to a vote of the minutes of the May 10th, 2018 meeting. Are there any corrections or comments to these minutes? Is there then a motion to accept the minutes? Mr. Carver, is there a second? Ms. Moskowitz. Then Ms. Rivera.
Mr. Carver.
Yes.
Mr. Barrett.
Yes.
Mr. Roos.
Yes.
Mr. Delaney.
Yes.
Ms. Torres.
Yes.
Chairperson Hilton.
Yes.
6 in favor, 2 absent.
Thank you, Mr. Rivera. The next, we'll turn to the June 7th, 2018 minutes. Is there any corrections or comments to those minutes? Mr. Delaney?
On page 23, I just, there's toward the bottom of the page, and by the way, the minutes are very thorough, and it's very helpful, and I'm sure it's a lot of work. But at the bottom of page 23, could you just explain your comment about pre-2006? I was a little unclear on the last sentence.
I'm sorry, just give us a chance to get there.
Sure.
The bottom of the floor, page 6.
Page 23.
Are you talking Ms. Balsam's comments?
Yeah,
Okay.
the last one.
Are you asking what was happening pre-2006?
The last 3 sentences, the executive director, I've taken them very literally. They get 1, but usually we give them for all of the ones they ask for. We don't make them come back each time.
Right, so depending on how you want to interpret the rule appears to contemplate that they have to apply for each extension separately. So let's say somebody's at the beginning of the process and they're asking for an extension of time to, let's say they filed the old one and they want an extension of time to get the permit, comply with 7B, and get the C of O. So the way that it's set up now, which is how it was when I came in, they could apply for all 3 of those extensions at one time, and we would grant all 3 instead of giving 1 extension for the permit, and then they have to come back and apply again for 7B, and then come back and apply again for the C of O. So that's what I meant by that. Does that clarify it?
Yeah.
Okay.
Are there any other comments on the minutes of the June 7th meeting? Do we have a motion then to accept these minutes? Mr. Carver, for a second. Oh, Mr. Barnes. Ms. Rivera.
Mr. Carver.
Yes.
Mr. Barrett.
Yes.
Mr. Roos.
Yes.
Mr. Delaney.
Yes.
Ms. Torres.
Yes.
Chairperson Hilton.
Yes.
6 in favor, 2 absent.
Thank you, Mr. Rivera. And now we have one last set of minutes to vote on. That's the June 21st meeting. Are there any corrections or comments on these minutes?
I just have a question. Scott, Mr. Barowitz is being here, but
I wasn't here.
yeah.
No. Okay.
I remember that. He was in a better place. So,
I hope we don't have him speaking anymore. That would be good.
No.
Okay.
with with that correction, is there a motion then to accept the minutes? Mr. Carver, is there a second? Ms. Torres?
Ms. Torres.
Ms. Rivera, you passed.
Mr. Carver.
Yes.
Mr. Barrett.
Abstain.
Mr. Bush.
Yes.
Mr. Delaney.
Yes.
Ms. Torres.
Yes.
Chairperson Newton.
Yes.
5 in favor, 1 abstention, 2 absent.
Thank you. As many of you know, Chief Ronald Spatafora, the fire department's designee to the Loft Board, passed away last month on 9/11 related injuries. We were saddened by his passing, but Chief Spatafora was the first fire department designee to this board, and so a few weeks ago, Mr. Delaney sent around an email suggesting to the board members that we pass a resolution in his honor, and we thought it was a good idea, and so we have a draft resolution to consider. I'm going to read that resolution into the record, and we'll, if approved by the board, or if there are any changes, we'll do that, but then we'll vote on it, and then next month we'll try to do something officially to present this to someone from Chief Spatafora's family here. So this resolution of the New York City Loft Board in honor of former Chief of Fire Prevention and Loft Board member Ronald R. Spatafora, adopted July 19, 2018. Whereas the New York State multi-dwelling law establishes the New York City Loft Board and charges the board with overseeing the timely conversion of inter-multi-dwellings from commercial and manufacturing spaces to safe, rent-stabilized residences. And whereas the Executive Order 129 dated May 22nd, 2009 establishes the fire commissioner as an ex officio member of the Loft Board, and whereas on March 18, 2010, the Fire Commissioner appointed Assistant Chief and subsequently Chief of Fire Prevention Ronald Spatafora as his representative on the Loft Board, and whereas Chief Ronald Spatafora was the first member of the New York City Fire Department to serve on the Loft Board and also a Loft resident, and whereas Chief Spatafora, a 40-year veteran of the Fire Department, began a storied career as a firefighter in Engine 237 in Brooklyn in 1978 and rose up the ranks until he became Assistant Chief of the Bureau of Fire Prevention in July 2010. And whereas Chief Ronald Spatafora responded to the World Trade Center terror attacks on September 11, 2001 and supervised both rescue and fire suppression efforts and was named World Trade Center Chief of Safety in October 2001 for the entire Ground Zero recovery operations ending in June 2002. And whereas Chief Ronald Spatafora died on June 23, 2018 of illness related to the destruction caused by the World Trade Center terror attacks. Now therefore, be it resolved that the New York City Loft Board honors him for his commitment and service to the board and the City of New York, and establishes a certificate of service award in his name for members of the Loft Board or Loft Board staff who demonstrate similar commitment and service to the Loft Board and to the City of New York. And it will be dated today. So this is a staff's draft of resolution in honor of Chief Spatafora. If anyone has any comments that they would like to do on this or any changes to it, otherwise we could vote to adopt this. Any comments? Okay, then we have a motion then to adopt this. Thank you, Mr. Roche. Second. Mr. Delaney. Thank you. Thank you, Mr. Delaney, for bringing the idea. Thank you very much. So, Ms. Rivera?
Mr. Carver.
Yes.
Mr. Barrett.
Yes.
Mr. Bush.
Yes.
Mr. Delaney.
Yes.
Ms. Torres.
Yes.
Chairperson Newton.
Yes.
6 in favor, 2 absent.
Thank you, Mr. Rivera. So, Ms. Helene Balsam, the Executive Director of the Loft Board, will now give her report.
So So I had put in your packages and sent you a report based on the report that Mrs. Delaney had sent to me regarding the milestone statistics. So the one that I gave you today was updated because we added a building. So currently we have 339 buildings. 213 of them are registered under 281 and or 281.1 or 281.4, and 125 of them are registered under 281.5. I'm very happy to say that out of those 339, 247 of them have already registered for fiscal year 2019. So the registrations are going very well, and as you know, we have a couple of more weeks before the late fees will start to accrue. So hopefully we have checks coming in every day. So that's that, the legalization statistics and the registration. In terms of the June revenue, we unofficially collected a little over $325,000. And then we had a good month in litigation, in the litigation department this month. No new cases came in, which is nice, so nobody's suing us. And in the bankruptcy case that I talked about last month, we actually had a favorable decision from the court. The debtor, who is the owner of a building under our jurisdiction, had moved to sell the property free and clear of all encumbrances, which would include the duty to legalize under the Loft law. The court denied the motion, finding that contrary to the debtor's argument, the interests of the IMD tenants were not subject to a bona fide dispute. The IMD tenants were not holdover tenants and had the right to remain in the building as long as it's their primary residence, and that the IMD tenants could not be compelled to accept a monetary settlement of their interests, even if MDL 286-12 allowed them to sell their rights. So that was a very nice decision to get from the bankruptcy court. The next case is 1099 Flushing Avenue versus City of New York and Dorina Realty. That case had multiple charges. Among one of them was the tenants were asking the court to annul a Loft board certification of a narrative statement and require owners to file new alteration plans and a new narrative statement. The tenants argued the Loft board sent the notices for the narrative statement to an incorrect address. I'll just say anecdotally, we didn't. The court found the claims were time barred because even if the Loft board mailed the notices of the narrative statement to an incorrect address, the tenants should have known that the Loft board issued a certification because the owner imposed a 3% rent increase on the tenants in August of 2015, but the petition was not filed until 2 years later. Finally, the last case is 517-525 West 45th Street, LLC versus the Loft board. The owner asked the court to reverse and annul a Loft board order which denied an extension of the code compliance deadlines. After oral argument, the court from the bench denied the petition, finding that the Loft board was rational and reasonable in denying the extension. I've given you copies of the two cases for which we have decisions from the judge. The other is just going to be a transcript.
Can you just repeat that again? The last case.
The last case. So the last case was a denial of an extension of code compliance deadlines, and the owner filed an Article 78. And the judge from the bench ruled that the petition should be dismissed and that the Loft board was rational and reasonable in denying the extension.
And the address again?
517 West 45th. 517 to 525 West 45th.
What was that case name, Elaine?
517-525 West 45th LLC versus New York City Loft Board.
Yeah, thank you.
I just haven't, I mean, I'm going to get a copy of the transcript from the law department, but I haven't gotten it yet. So if you want it, I can certainly send it along, but I don't have it right now. And
Well,
that's it.
actually, one more thing, Elaine, on the bankruptcy case. Is this the first time the bankruptcy court?
Yes, it was a case of first impression. Yeah. And he says that in the decision, if you read the decision.
Any other questions for Ms. Walton?
I'd just like to thank you for having put together that table. And I think it's very helpful, and it goes to show that actually the loft law is working reasonably effectively, in the sense that the number, compared with the 2014 sheet that I passed around, so it's exactly 4 years, the number of buildings covered under the original law continues to diminish, and the number of buildings covered under 281.5 has increased from 84 to 125. And the good news is that we have a lot of buildings that are kind of at or near over 100 of the 339 appear to either be 7B or having received the C of O, and we only have a total of 26 buildings that don't seem to have gotten started yet and haven't filed an O1, and only 2 of those are from the original 281.1. And I think it'd be nice to know who they are and see what they can do to encourage them to get out onto the track and leave the dressing room and start the event.
Well, Ms. Lavelle is going to actually talk about that, but I do want to say, though, that just because a building's covered under 281.1 and or 4 doesn't necessarily mean that it dates from a long time ago. Like, we had one recently that had happened to have filed under 281.1 and the board found coverage. So even though it was, they were going back to a really early window period, they were still able to prove that people were living where they needed to. So with that caveat, yeah.
Okay, any other questions for Ms. Balson? Thank you, Ms. Balson. For the next presentation, I just want to say thank you to them. I'll talk in a second, but this presentation on New York City Loft Board's enforcement plan was put together by our Assistant General Counsel, Cynthia Lavelle, and our intern, can't get it right, but I'll get it one day, and our legal intern, Sean Raffington. So thank you both for that, and the floor is yours.
Thank you. So as was previously discussed, although there's some buildings that have been making a lot of progress towards legalization, there's always room to help provide assistance to owners. Weird. Okay, I said it. Yeah. There's always room for growth to help buildings, and building always move quickly through the legalization process. So the staff was tasked with this assignment to come up with an enforcement plan to help buildings and owners move through the legalization process. So because there was a very comprehensive plan in mind, we thought it was best to break up the proposal between 2 parts. So part 1 will essentially focus on, once you see, available tools and current practices. Now, the available tools are the potential measures that are available under the existing law and the board rules. And also the current practices covers what we currently do in enforcement generally. So because I was given a time constraint, I would kindly request if you could reserve your questions to the end of my proposal. So general overview is we're going to start with the enforcement proposal objective. Because there are 339 buildings in the Loft Board universe, Sean Raffington is going to walk you through the breakdown how we categorize the buildings. And also you see that the enforcement measures are broken up into 2 types. Legalization, which is the meat and bones of this proposal, and also the general enforcement measures. So, and the general objective is to induce compliance with the legalization requirements of the Loft law and encourage overall compliance with the Loft Board rules. So that's what we had in mind when coming up with this proposal. And I'm going to leave it to Sean to discuss the categories. So this is is a breakdown of all the buildings currently under the Loft Board's jurisdiction. So it's broken down into categories and subcategories based on the milestones. So the first one are the buildings that have no alteration one application file, that's category A. So basically they are registered buildings with IND numbers, but they haven't done anything yet to start the process. There are 26 buildings in that category. B1, they file their alteration applications. This is an application requesting that DOB issues a permit authorizing performance of certain construction work on IND buildings, and that's filed by an architect or an engineer. There are 28 buildings in that category. B2 are the buildings in the open narrative statement process. This is a chance for the occupants to review and comment on the owner's construction plans that he has for the IND, and we have 42 buildings in that category. B3 is Loft Board certification. That's where the Loft Board certifies that the narrative statement process is complete, and this is needed in order for DOB to issue a permit. We have 5 buildings currently in that process, in that category. Next for C, these are alteration 1 permits. These are the permits that they need to begin the work. We have 132 buildings, and we further broke that down into which buildings have active and expired permits. For 7B compliance, category B1, that is a certification that the building is in compliance with the fire and safety standards of the multiple dwelling law, and that's certified by an architect or an engineer. We have 31 buildings in that category, and the temporary certificate of occupancy, category B2, that's the equivalent to 7B. And there are 31 buildings in that category as well. For E1, these are buildings with final certificates of occupancy without pending removal applications, meaning they've gone through the process, it's finished, but they have not filed to be removed from the Loft Board's jurisdiction yet. We have 20 buildings in that category. And finally, for category E2, these are buildings that do have final certificate of occupancy, and they have filed for removal. They're just waiting to be removed. And there are 24 buildings in that category. And so essentially, if you could think of this as a race, the A category buildings are those at the beginning of the race. And of course, as you can see, E2 is pretty much at the end of the race. And Trishant did mention that, that we are in the process of further breaking this down. I did mention that part 1 of the plan would kind of just discuss what the available measures are and general enforcement. Part 2 of the enforcement plan will really break down these different buildings, and of course through board recommendations and suggestions, we'll come up with a strategic plan about how these potential measures can be implemented according to these different categories. So in terms of the legalization enforcement, as I mentioned, it's been broken down into, again, subsection or characteristics of the type of enforcement, cooperative and punitive measures. The cooperative measures, as you can probably guess, is more cooperative, doesn't involve imposition of fines or violations, as opposed to the punitive measures, which will ultimately be recommendations for issuing fines and violations of subsequent fines, and also involves litigation. So with respect to the cooperative measures, one of the suggestions we have is informational letters / warning letters. So essentially the letters would be sent out to the different owners in the different categories, saying what legalization stage you're at the current moment. It can provide potential information or general insight as to what the next steps are. It can also, of course, advise staff will be here to answer any questions. And in terms of the warning aspect, it will essentially let owners know that if you don't make efforts to legalize, that you could be subsequent to a violation or fine. And this actual owner informational sessions, suggestion number 2, we actually adopted from board member Torres Moskowitz. She did come up with a suggestion of doing informational sessions for owners, so that's something we thought that we can do. Again, it'll be an opportunity for staff to kind of inform owners of what the process is with the explanation. It would also be useful in the event that there is a new waiver period that's implemented and new buildings who may not, or owners who may not be familiar with the process could get more information. The last measure is legalization conferences. It's essentially what it sounds like. Staff would be meeting with the owners, design professionals, or any other representatives that owners feel necessary to discuss any of the legalization obstacles we may feel that they have. We can ask answer any questions, if possible, of course, provide any insight on how to move to the next stage of the legalization. Now, this measure is not necessarily, doesn't really fall into legalization, but it's interconnected in order to adopt these measures of reaching out to owners. We feel that it's necessary to start potentially imposing fines. The rule section 205 requires owners to submit any changes of information, change of ownership, emergency contact information within 5 days. Sometimes we have a situation where that's not being updated. And to update is pretty easy. There's just a form online to submit however you choose to submit, advising of the change. But the change must be, staff must be notified of the change within 5 days. So the proposal suggests that for owners who have not submitted the form within 5 days to start imposing a fine, and the violation first, so it's the notice of violation first, notice of violation first, then the notice would give owners the opportunity to advance any arguments if necessary, and then in position of fine if staff feels it's necessary. And also I wanted to advise that these forms get sent out in the registration renewal packages every year, so it is available. So in terms of punitive measures, it's broken down into two. Failure to take all reasonable necessary action, which comes straight from the rules and the statute, and specific performance actions, and further break that down. So section 201.1B1 essentially allows for two types of measures. One requires hearings and inspection, and another one doesn't require hearing and inspection. So for the hearing and inspection one, it's essentially the rule allows the executive director to send an inspector out to verify what work is being done towards legalization. That inspector will submit a report, and that report is considered prima facie evidence of facts contained, which basically means that the facts in the report stand to be true. And from there, staff can issue a notice of proceeding if it's believed that the work or lack of work is insufficient to adhere to the rule. And once the notice of proceeding is issued, owner of course has an opportunity to submit some form of response. If staff still believes that it should be further enforced, then it has to be referred to either oath or ECB, and they will conduct the fact finding. The oath ALJ or the ECB hearing officer will also make a determination as to whether there has been a violation and if what fine should be imposed. And you see here the fine is $1,000 per day up to $17,500 max. So the second aspect of section 201.1B, these are the potential measures that don't require any hearing. So the rule requires that the executive director can issue notices of violation for when owners fail to essentially either file or maintain a certain kind of permit, and it's broken down here within a certain amount of time. So as you can see here, the alteration 1 application has to be filed within 6 months of the issuance of IND number, and then for the alteration 1 permit, it has to be obtained within 3 months of certification. And then you see here, it's a violation for failing to maintain an active alteration 1 permit, as well as maintain an active temporary CFO. So again, with these measures, there is no referral to oath. It's just simply a notice of violation is issued, owner has, of course, an opportunity to respond, and then there's an imposition of fine if it deems necessary. And again, it's a fine similar to the other one of $1,000 per day up to $17,500. Now, specific performance actions, these are a little different in terms of the multiple dwelling law, allows for essentially the law for to commence an action requesting a court of law, which would be, in this case would be Supreme Court, to ask, essentially is requesting the court to direct someone to do the work that they're supposed to do. So this is not necessarily monetary punitive measure, but it is essentially telling the owner, if it is granted, you have to do the work to legalize. But the rule requires that before you do that, that the loft board must first make a determination, essentially a finding that the owner failed to meet the code compliance deadline because the owner did not exercise all reasonable necessary action. So in trying to figure out what kind of finding or what kind of application would the board be able to make such determination, we came up with two measures. And for some of you who are new to the board or are not familiar, in the past, the loft board used to do these loft board initiated actions. It was documented, this BB documents, for owners who were alleged to have violated the code compliance timetable. So in these actions, there was essentially a board decision advising whether or not there was a violation or not, and also imposing a fine if necessary. So we feel that these potential OBV decisions could be used as a precursor to commence specific performance actions. Also with the and also with the failure to take all reasonable necessary action, that is all over the rules and the statute. And staff is proposing to create a new docket, essentially a new type of application, which is not tied to code compliance deadlines or anything else. It would be more of a general violation. You failed to exercise all reasonable necessary action. And this measure would allow more of a strategic enforcement of potentially bringing enforcement measures against owners who may not fall within any of the specific categories. And this measure here, although we're still in the strategic planning phase, this would not be a default go-to measure because it is litigation, but it's definitely something that could be useful to. And now we're moving on to the general enforcement measures. So these are all the measures that staff currently employs to encourage general enforcement. So you have the failure to timely renew buildings annual registration, which the board knows as ECHO dockets, and that's been consistently done for a decade, I believe now. Also, the failure to maintain the minimum housing maintenance standards is something that essentially our inspector assigned to the loft board. If he hears a complaint, he investigates, and a lot of times it doesn't really result in violations because through negotiations and communications between owner and inspector, a lot of the issues get resolved. The last three that you may not be too familiar about are the failure to file the monthly legal progress reports. And actually, there was a case, so there are two cases before the board. So essentially, I'll just recap. The rules require that any building that has, or any building owner that has a building that has received loft board certification but has not received the final CFO, required to submit these monthly progress reports. It is basically a snapshot of what measures what you're doing towards legalization. So we do compliance checks twice a year. If for that given month there is a building is required to owner is required to submit a report and it's not there, the notice of violation is issued. There is a 30-day cure period. And the cure period allows for either submission of the missing report or the current month. And if that is not cured, then the executive director issues a $1,000 fine, and via administrative determination, which is subject to appeal. So the owner can appeal and it will go for court. And another measure that you may not know about is we are enforcing the failure to timely file the Article 7C sales filings. Essentially, as you can see here, Rule 210 and 207 require any sales filings regarding sales of improvements or sale of rights be filed within 30 days of the date of sale. So when they come in, the filings are reviewed for any deficiencies to determine any latenesses. If there are any deficiencies, staff does reach out to owner to allow an opportunity to cure the deficiency. If it's untimely, then a notice of violation is issued for the late filing. The owner has an opportunity to respond as to why the fine should not be imposed. And if necessary, then administrative determination is imposed, issuing a $4,000. And again, it's subject to the same 45-day period to appeal if necessary. And then the last one is the failure to post the IND signs. Section 205 requires you have to submit the IND notice or an IND sign in the lobby, and it's basically a little sign that the law enforcement staff has previously mailed out, which basically lets tenants know and anyone else know that the building is an IND. And the rules require that the sign must be posted within 5 business days of the issuance of the IND number. So our inspector has been periodically checking to see if there has been compliance with this. And my understanding is also that staff has been, during this registration renewal period, advising, reminding owners, please make sure your signs are posted. And this, to enforce this, it just requires a notice, and imposition of the fine could be $1,000. So those are essentially all the current measures that we're employing. And then right here just gives you a schedule of the fines and which section of the rules you can find in. And just to sum up, again, this part 1 of this plan was just to give you a general overview of the different measures. The legalization measures we're proposing for the board to consider. And then part 2 will get into the real strategic aspect of it and specific recommendations. And we plan on doing that second part in September, the September meeting. And then also we'll be looking for the board's input in terms of, essentially, I mean, it's an open field about whether the board wants to give suggestions in terms of measures or, where we should start or buildings that we should focus on. So that's pretty much it. Any questions?
Thank you very much.
I have a couple. Wait. I'm sure others do too.
Yeah.
So this standard of reasonable and necessary action, is that phrase coming out of the statute or rules or both?
Statute. Well, both, yes.
Both. And are there any cases that say what that means, reasonable and necessary?
It's defining the rules themselves as deliberate, diligent, and consistent action in terms of fact-specific cases. I know we're still in the investigation aspect and seeing how it would play out.
Right. So there's actually no actual case that actually uses that standard to actual facts?
No, I didn't say that. We haven't researched it because I haven't researched it yet. So, because that's not the stage we're in. The goal was to figure out what the rules allow as potential measures, and then to further, the time permits, do the investigation whether or not how it can be implemented.
Okay, but
under what circumstances.
Suppose if there are cases, they would be quite old at this point, yes, if it's not something that comes to mind easily. Okay. Secondly, the monthly filing that owners are doing, and I know that's a subject of some of our cases today, do you really need that filing every month?
So we had actually talked about this with the rulemaking, and I think the recommendation was to make it quarterly, but that suggestion didn't make it into this rulemaking.
Oh, maybe it's not even know, maybe it should.
Well, maybe we need to do some rulemaking and not keep adding things, I think.
Any other
Oh,
questions?
sorry.
I had a question.
So fast, that's okay.
Yeah, no, I was just thinking about the monthly versus quarterly question. I'd certainly support a change to quarterly. I don't think monthly is really that necessary. It's a lot of work for owners. And if these architects, I guess that architect must charge $1,500 for a report or $1,200, right? Take the $1,000 fine, better deal. On the question of permits active versus expired, I think you said we have some numbers around that.
We do. It's for the alteration. Do you have the numbers? Yeah, it's been pretty broken down.
Yeah, just rough.
Yeah, sure. Okay, so based on Trishon's numbers, it's 45 active, 75 expired. 57 expired alteration permits, 9 with multiple expired. I guess there are multiple alteration numbers, and then 4 buildings in process. And then there are 2 miscellaneous ones that
Okay. So the takeaway is there's slightly more than half of the buildings that have permits have expired.
Yes, that's correct.
And In terms of, I gather the timetable that you contemplate is that the board would give this more discussion at our next meeting, which is scheduled for September. And some of this, I guess my question is to what's required to implement those portions of this which are new?
You mean in terms of staff's perspective, or are you just trying to do it?
Well, yeah, I think staff's perspective.
I mean, we would have to set up, like the basic, you have to have, well, we'll need IT to set up the notice of violation in the system. We'll need to set up the docket to be able to track it, and so that the fines would appear on the invoices. We'll have to set up standard operating procedures as to how we're going to issue and what the consequences are. So, there's a certain amount of implementation, and I don't know that it's extremely burdensome. The tracking is going to be the hardest part after we get going.
Okay. It seems to me that what we've heard is all are good ideas. On the informational side, holding informational meetings for the owners, which certainly can't hurt and might help. Is that something that you feel the staff, that you have the resources for?
Yeah.
Yeah.
I think that was the goal of having cooperative measures, and something that wouldn't be too taxing on staff to implement.
Yeah.
So that's something.
Okay. And then it is clear that something which over the past 30 plus years has not happened, the notion of the board bringing a case for specific performance, the law is quite clear that requires a prior finding. So that's something, and I certainly have some candidates. So I appreciate your adding that to the mix. The other question with regard to this failure to update owner contact information, where we're going to issue a notice of violation. My question is, how do we know?
So the best way to implement that would be during the annual registration renewals. The form includes on the bottom date of change. So for date of change, if it's for ownership, it's easier to look up. You can verify via Accuris that there's been some kind of change of ownership. But for the owner to change your address or future address, upon looking at the actual information sheet submitted, if you've had any return mail, that's a good indication that that old address wasn't valid. So that could be a way of doing it. But it would be recommended to kind of do it with annual registration renewals as they come in.
So if I renew the registration in July, and I know that I'm a new owner and I purchased the building in February, then a notice should have been filed then.
Correct.
So, but now we pick that up. How do I cure that?
There's no
Yeah.
provision.
Okay. Right, okay.
You remember that whether or not it's curable is actually contained in the penalty schedule. So some of the provisions have cure provisions, and some of the methods have cure provisions, but others don't. This one, I believe, does not, right?
Can you just define cure?
It's when you issue a notice of violation. Cure means you have an opportunity to fix whatever it was that got you to receive a violation. Without penalty, yes.
Okay, I think so.
Yeah, I just wanted to add thank you so much. Between the milestone statistics and this, it's so much more clear for me as a new member. I had one question about the failure to timely file Article 7C sales filing. Is that something that's ever been imposed and enforced before?
We just recently started doing that.
Yeah, so maybe a few months, let's say within 6 months, we've been, as we review the sales file to see if it's timely or not. And then I believe we've issued about 4 notices, and the owners have responded, well, correction, for 1, there was no response, and then for 3, there was a response. And for 1, actually issued an issue determination, the owner tried to withdraw the filing, and then actually paid the fine. So we issued a determination saying that you paid the fine as an admission of your violation, and also advised that trying to withdraw the filing does not remedy or avoid the imposition of the fine. So,
Are you allowed to keep a list of statistics on sales, not including numbers of, like dollar numbers on sales?
We don't know the dollar numbers all the time.
Okay.
Currently, well, we changed the form, so there's nothing in the rule about sales filings that says that they must disclose the sales price. The former form said that the owners could redact the sales price. We changed the form and we took that off, but we can't compel them to tell us the sales price unless we have a rule. So we're now no longer encouraging them to redact, but we can't compel them.
Thank you.
And we are soliciting, I just want to reiterate, we're soliciting board input, in terms of where you think we should start. So if you could kind of think about that between now and September, where would be the good places to start, because there are a lot of different options. So do we want to move people that are close to the end of the process along, or do we want to start with people that have done nothing for years and years? So, sort of think about that.
The priority.
Yeah, what you feel the priorities should be.
Well, maybe we could devote a few minutes to that right now, because I certainly feel strongly that the people who've done nothing create a baseline of disrespect for the board's mission. And it's my feeling that...
Just before you do, I think you're going in a different direction. I think he has something on the presentation.
Oh, sorry.
So go ahead.
It's on the same line, so
Oh, okay, sorry.
I'll wait.
All right.
Thank you.
Yeah, no, I think a couple of high-profile cases for the people who were really lagging behind and who've basically done nothing. And we've got some people who have never filed anything, haven't even bothered to renew their registration for 4 or 5 years. In my opinion, the way to get everybody moving forward is to start with the ones who are most egregious in not having done it.
Mr. Carver.
I'm somewhat concerned about staff being pulled in so many directions, and I know that the pipeline of, the timing of our cases getting through the pipeline is very slow, and we're often commenting how slow it is. Sometimes parties bring mandamus proceedings in court to make us rule on something. And I'm somewhat worried that, I'm not saying we should not do things along these lines, but I'm actually very worried that putting resources here will cause the pipeline of cases to suffer. And I think everyone agrees, well, maybe never, I think the pipeline right now is too slow. And I see this as making that even slower.
Well, what does staff have to say about this? What is our backlog? Do we have any idea?
I don't know the current backlog. We did give statistics. I don't remember if it was April or May.
Is that what
Yeah,
60 cases.
60 cases.
The bulk of them are summaries. The master calendar, I didn't have that information. So we have 14 master calendar cases on the list for presentation to the board. So that leaves, what's that?
46.
of that 60 are summary cases. So in the master list, we have, 3 coverage, 3, it's not a huge number.
Yeah, but I point out that looking at number 3 on the calendar today, that took over 1 year to be decided, I think. It says June 23rd, 2017, tenant filed an application for reconsideration. And now we're in July, which is over 1 year for, for an issue that's not all that complicated.
Well, what would it take for staff to accelerate this problem? Is there a possibility of going into the mayor's office and say that you need additional staff?
Additional resources.
Is that no go? I mean, a lot of things in the city has been dragging. And, while I agree with what you're saying, but the fact that the staff is limited, and I'm sure they're working very hard, full-time, trying to get this thing presented to us. But I don't know if there's a solution outside of saying, well, you're worried that it's going to take even longer. But we have to follow the best as we can. Our own rules and procedures, unless you can come up with another series of circumstances to make all of this work simpler, but I don't see how it's going to happen. And it looks, stop me if I'm wrong, Chuck, it looks like things have gotten far more complicated in the last, since 2010.
More complicated? Bigger buildings.
Yeah, bigger buildings.
And a lot of the complication
Eligibility requirements.
is because of the legislature.
Yeah, that's right.
If I could just address your comment, though, I think it's a legitimate concern, but I think we have to try and do some enforcement, and what we can do is keep an eye on it, and if we feel that the backlog is growing in a way that it shouldn't, in terms of time or in terms of numbers, then we can cut back on enforcement. But I do think that we need to try, because there are buildings that are just stalled, and, we do want to try and move them.
Okay, so maybe it makes sense to be careful about what we're selecting.
Right,
Maybe that's the solution.
right.
I don't know.
I have another question about the content. Under failure to take all reasonable and necessary action, it's 1,000 to 17.5 a day. How do you suggest?
1,000 per day.
Oh, up to.
Up to 17.5.
I get it.
Up to
Oh, okay.
17.5 is
Whatever
the limit in the
17.5, they
statute.
just
It's the statutory limitation.
limitation, so you can't go higher.
Can't go past that. That doesn't mean the violation doesn't continue past that, but that's the maximum you can go.
Okay.
I have actually, I'm glad you brought it up. The one that talked about failure to maintain an active temporary CBO, does this mean when it's expired?
Right, they give you that expired.
Oh, okay. And does the fact when they reach the maximum, can you reissue the violation?
Yeah,
So we can,
for the ones that require hearings, they can only be issued every 3 months. But the other ones, I don't think that there's a limitation.
The 3-month limitation
It's
stems.
in the rule. It says for the ones that require hearings by oath or ECB, oath ALJs or hearing officers, they can only be reissued after 3 months. I'm not sure what the rationale was, but it says that, so we're bound by that.
so I think it's just a matter of balance. We have to try to balance stuff somewhere, and of course, we'll bring back the concern about staffing where it belongs, but we have to start somewhere before we do that, and we couldn't just go and say we need 10 people to do something that we haven't even tried to start to do yet. So I first want to thank Cynthia and Sean, for your work on this, but, and as you see, it was kind of detailed, and I thank the board for all, for anticipated comments on this, and you know, let's get back in September and reconvene on this and see what you got, so that we can do something, because the bottom line is something, you know, we can't let the system be a mockery, you know, make a mockery of other folks, make a mockery of the system. You know, this law is a law, it has to be followed. I'm sorry. Yes, you agree? Okay, good.
Agree.
Thank you. Okay, we now turn to a vote on this month's cases. We start with the appeals and reconsideration calendar. There are 3 cases on the calendar. The first is Dallas Realty Corp., 83 11th Street in Manhattan. The docket number is AD 0089. And Mr. Winters will present this case.
So on June 28, 2017, the Loft Board sent the owner of 83 Leonard Street a notice of violation for failure to file a monthly report in May of 2017. Owner was then given 30 days to cure this violation. After they failed to cure this violation 30 days later, the executive director issued an administrative determination imposing a $1,000 fine for failing to comply with the rules. On September 20, 2017, the owner appealed this determination, alleging that an undisclosed architect sent the monthly report in a timely manner. To this date, Loft Board has no record of receiving the report until it was attached in the appeal of this matter. The proposed order for you denies this application challenging the determination.
Thank you, Mr. Winters. Does anyone have any comments about this case? Do we have the motion to accept this case? Mr. Roberts, is there a second? Ms. Torres? Ms. Rivera?
Mr. Carver?
Yes?
Mr. Barrett?
Yes.
Mr. Booth?
Yes.
Mr. Bellini?
Yes.
Ms. Torres?
Yes.
Chairperson Hilton?
Yes.
6 in favor, 2 absent.
Thank you, Mr. Rivera. The second case is George Watchell at 24 Bond Street, Manhattan. AD docket number is 800094, and Ms. Rackington will present this case.
On March 28, 2018, Executive Director Lawson issued an administrative determination imposing a fine of $1,000 against the owner of the building for failing to file a complete monthly report for December 2017 pursuant to 29 RCNY Section 201.18 of the Loft Board Rules. On April 10, 2018, the owner filed an administrative appeal challenging the administrative determination. The owner alleged that the Loft Board is equitably stopped from imposing this fine because for 2 years he submitted reports that were signed and unsigned by professional architects, and the Loft Board accepted both without objection. However, the case law shows that equitable estoppel can only be applied to governmental agencies in exceptional circumstances which are not present in this case. The proposed order before you denies the appeal application.
Thank you, Ms. Rao. Does anyone have any comments on this case? Do we have a motion then to accept this case?
I'll move.
Thank you, Mr. Day. Do we have a second? Ms. Rivera?
Mr. Carver?
No?
Mr. Barrett?
Yes.
Mr. Booth?
Yes.
Mr. Bellini?
Yes.
Ms. Torres?
Yes.
Chairperson Hilton?
Yes.
5 in favor, 1 against, 2 absent.
Thank you, Mr. Rivera. The last case on the appeals and reconsideration calendar is James Ruhlman at 442 Broadway, Manhattan. The docket number is R0358. Mr. Clark will present this case.
Thank you, Chairperson Hamilton and board members. On March 7, 2011, the tenant of the third floor in the building filed an application seeking coverage pursuant to Section 281.5 of the MDL. On December 9, 2016, after the administrative judge issued the report and recommendation the Loft Board staff received a letter from tenant requesting to reopen the administrative record to introduce additional evidence. In a letter dated December 23, 2016, the Loft Board staff responded to tenant's letter denying tenant's request because the Loft Board rules do not provide for reopening the administrative record after the issuance of a reported recommendation. On May 18, 2017, the Loft Board issued order number 4671 denying tenant's application. On June 23, 2017, tenant filed an application for reconsideration of the order, alleging denial of due process because the Loft Board failed to make a record of the request to reopen. Pursuant to 29 RCNY Section 1-07A, the allegation of denial of due process must occur in the prior proceeding. The prior proceeding includes the entire adjudicated process up until the judge issues the report and recommendation. Since there was no denial of due process in the prior proceeding, tenant failed to meet the standard for granting reconsideration. The Loft Board staff's response letter acknowledged tenant's request, answered the request, and explained the basis for the rejection. We disagree that the inclusion of the request in the background of the order is necessary to provide a proper record. If tenant wanted to preserve his right to appeal, tenant should have appealed the denial of his request to reopen, but failed to do so. For the reasons stated, the proposed order before you today denies the reconsideration application.
Okay. Thank you, Mr. Clark. Does anyone have any comments about this case? Okay. So we have a motion then to accept this case? Mr. Carver, is there a second? Mr. Bowers, and Ms. Rivera, please call the vote.
Mr. Carver?
Yes.
Mr. Barber?
Yes.
Mr. Roach?
Yes.
Mrs. Delaney?
No.
Ms. Torres?
No.
Chairperson Hinton?
Yes.
4 in favor, 2 against, 2 absent.
This motion is passed. No. Then confused. Okay, this motion is not passed.
That's because of the 2 absentees, which is
Well,
really,
it's either, I don't know if their vote would have been,
no, I know, it's sort of, I mean, in some ways, it's a terrible rule to consider the 2 absentees as present, whereby the majority doesn't rule.
It's a
And
state law.
I understand, and it's really terrible. I just want to go on record. I think I've said this before.
yes, you have.
Yeah. Okay.
All right. So this will be recalendared for September. All right, there are 6 cases on the summary calendar. They're voted on as a group. However, we are going, at one member's request, we're going to be taking number 7 out and voting on case number 7 separately. In fact, let's do that first. This case number 7 is tenants of 50-17 5th Street. They're the applicants, and the address is 50-17 5th Street, Queens. The docket number is TR1291. Does anyone have any comments or question on this case? Does anyone have any comments or question on this case? None. Is there a motion then to accept case number 7, tenants of 50-17 5th Street? Mr. Carr, is there a second? Mr. Barnes, thank you. Mr. Barnes, then do we have Mr. Rivera?
Mr. Carver?
Yes.
Mr. Barber?
Yes.
Mr. Roach?
Yes.
Mr. Delaney?
No.
Ms. Torres?
No.
Chairperson Hinton?
Yes.
4 in favor, 2 against, 2 absent.
If that's the same result, that motion is not passed. This case will be counted for next month. Therefore, let me read the other cases on the summer calendar. These other 5 cases will be voted on as a group. They are John Thorson, Kimberly Thorson, and Ted Tyler Hayes. The address is 442 Broadway in Manhattan. The docket number is TR1089. The next case is Adam Snyder and Cecilia Cutler at 73-77 3rd Street in Brooklyn. Sorry, that's 73 through 77 3rd Street in Brooklyn. And docket number is TR1238. The next case is Gabriel Phillips, Annie Sessis, Sarah Marie Young, and Ashley Williams at 73 through 77 3rd Street in Brooklyn. The docket number is TR1264. The next case is Heather Mary Jackson, Brenda Blank, and James Walrod at 302 through 306 Grand Street in Manhattan. Docket number is TR1319. The next case, and final, is Elizabeth Santique and Karen Casamasino at 36 through 40 West 29th Street in Manhattan. That docket number is TR1356. Does anyone have any comments on this case? Is there a motion then to accept these cases? Mr. Carr. Your second. Mr. Rouge. Ms. Rivera.
Mr. Carver?
Yes.
Mr. Barber?
Yes.
Mr. Rouge?
Yes.
Mr. Delaney?
Yes.
Ms. Torres?
Yes, but I just want to say in case 8, I know I know the person who's deceased. I just,
For the record.
for the record.
Chairperson Hilton?
Yes.
6 in favor, 2 absent.
Thank you, Ms. Rivera. The master calendar, there are 3 cases on the master calendar. They're all removal cases, and they're voted on as a group. Before we do, though, Staff Attorney Stephan Clark will discuss changes to case number 10 as discussed in our private session.
Thank you, Chairperson Nelson. I'll be reading in to the record changes to case number 10, LE 0595. First, on page 3 of the proposed order, in the 4th paragraph, the very last date, March 2026, will be changed to February 2026. Again, on page 3, the very last paragraph, the last date of March 2021 will be changed to February 2021. Additionally, in the conclusion of the proposed order, we will add an additional column to the chart with the total cost of code compliance, and we will add a footnote to that addition, which reads the code compliance costs are not part of the initial legal regulated rent. Any further RGB increases shall be based on the initial legal regulated rent only.
Thank you, Mr. Clark. All right, does anyone have any comments or questions on these cases? Therefore, do we have a motion to accept these cases? Mr. Carver, is there a second? Mr. Barnes. Thank you, Mr. Barnes. Mr.
Mr. Carver?
Yes.
Mr. Barber?
Yes.
Mr. Rouge?
Yes.
Mr. Delaney?
Yes.
Ms. Torres?
Yes.
Chairperson Hilton?
Yes.
6 in favor, 2 absent.
Thank you, Mr. Rivera. So we have half an hour to discuss, going to and to start discussion of both which Ms. Balsam will lead, but sometimes because of the discussion gets a little heated, so I just want to, before we do that, I want to give hail to our 2 interns, Trishan Rafi and Ben Winter, who has been with us now for about a month. And the next time we meet, it will be September, and they'll be back in school. So Trishan hails from Hofstra, and Ben hails from Benjamin Cardozo, and I just wanted to say thank you very much for your service, and I appreciate it. I hope you learn a lot. I hope you can bring a lot back to your fellow classmates and maybe to your instructors and teach them some stuff. But thank you again, and thanks for your service to the city.
Yes, thank you.
Come back anytime.
All right, Ms. Paulson.
So I have a couple of preliminary matters before we kind of pick up where we left off. First, I want to bring to the board's attention an issue regarding cross-references, which, as you know, is not one of my favorite things. So we are renumbering Chapter 1, and it occurred to me that we have a lot of cross-references in Chapter 2 to Chapter 1. So all of those cross-references will have to be changed. So before we go to publication, I'm going to insert those changes to cross-references into the proposed rule, but since there are 38 of them, I don't want to do it now because this document is already pretty unwieldy. So just so you'll know, that is coming down the pipe. Okay? And this is why I really hate cross-references. Next, I wanted to talk about the discussion of a protocol for considering rules, which the board had brought up last time. And there were 2 board members that had sent me suggestions, and based on those suggestions, I gave you a document, but basically what we think would work, and of course if you feel otherwise that's fine, is that the proposed changes would be sent to the executive director, and sometimes staff may have changes too. The executive director would send those proposed changes to the board members at least 2 weeks prior to the next board meeting. At the board meeting, the board members would vote on whether to even consider the proposal, because why debate it if nobody wants to consider it? And if the board votes yes, then the matter would be placed on the agenda for the following board meeting. So does anybody have any comments or questions or suggestions? Is there a better way you think to do it?
I think our current rules have a process for putting something on the agenda, and it's less than a full vote of the board, right?
3 members.
Right.
Put
I
something on
mean,
the
as
agenda.
a practical matter, why would we want to put something on the agenda that lacks the support of all? But nonetheless, in the process of talking about it, I mean, the 3 members that are interested in it might get more votes, so I imagine we would want to stick with the vote that the rules say in terms of putting something on the agenda.
So you would suggest changing it to at the board meeting. If 3 members want to go ahead, then we would go ahead.
I think we have to, actually, in order to be
Okay.
consistent with the rule. I don't think we have a choice, I think.
Let me see if the current rule, in chapter 1, if I recall correctly, says that matters can be placed on the agenda at the request of the board member, but that the chairman determines when it goes. It doesn't go on the agenda that. Well, since this is, I don't think this has ever happened, so to that extent, there's not.
Well, yeah, I'm thinking that but look, if 3 members think something's a good idea, and they should have the opportunity to have the matter fleshed out at a meeting, I suppose, as opposed to needing a majority, as is proposed in the memo here.
And I'm fine with that. At least 3 members with the chair determining when such matter is assigned. Okay, we'll change that.
I had one question too. I think when I spoke to you, I had suggested, is there like an end to when we can keep adding new topics?
It seems to never end.
Yeah, I mean,
think that's just discretion of the chair, I think.
okay. It doesn't have to be written, I guess, into the document. I don't want to, yeah, I don't want to be pinned down, but yet I like the idea that we are moving forward.
Yeah, I think you can, chair's responsibility to move things forward. But I don't think you will pin down like a deadline for others.
So September would be the next, if this goes into effect, so something could be on the September agenda.
Yeah, well, I mean-
It's up to the discretion of the chair. It's like the Senate Majority Leader of the U.S. Senate. They can hold off and not do it, is that correct?
Well, hopefully not. Hopefully that aspect
Well,
of it would not
that's
be.
what the chair
I'm afraid to disagree.
Okay.
Yes, that's true. I think.
So what we could do is that we could say, if the board votes yes, then at the discretion of the chair, then the matter is placed on the agenda for the next board meeting.
Well, no. Why are we imposing that extra obstacle that's not in the memo currently?
Well, that's the rules.
Because that's normal procedure.
Well, the chair can waive that now.
The chair can waive it at the time, but not now.
Don't worry, I'm the next one. So where are we here?
So proposed changes are, go to the executive director.
That we're all in agreement.
Yeah, we're all in agreement then, okay? The executive director sends the proposed changes to the board members at least 2 weeks prior to the next board meeting. At that board meeting, the board will vote on whether or not to consider the proposal, and if at least 3 members want to consider it, it will go forward. And if 3 members want to consider it, at the discretion of the chair, the matter will be placed on the agenda for the following board meeting. That's where we are. Okay.
So the matter was placed at the earliest for the following board.
Yeah.
So now this more or less comports with what's in the rules currently,
Yes.
which leaves us with 2 separate inroads. This fleshing out what's in chapter 1, and also the petition
Petitions
for
from the
rulemaking
public.
from
Yeah.
the public.
Mm-hmm. Right.
When does a petition from the public go onto the agenda? Is it required to go right on? How does that work?
I gotta look it up. I don't remember.
I'm asking because that overrides the chair's ability to delay.
Yeah. Hold on.
Okay.
Um,
Of course.
The petition is forwarded, so the petition is received from the public. It's forwarded to the chair, who may, at his or her discretion, reject the petition or present the petition for consideration to the board. If the chair rejects the petition, he or she must do so by written notice stating the reasons for the denial, copies of the rejection, together with a copy of the petition, are presented to the board at the next regularly scheduled session, after which any board member may present the petition for consideration by the board.
Oh, so okay, so any one board member can override the chair by bringing his own petition, in essence.
Well, the petition would have to be sent by somebody from the public first, right?
All right.
And then it says any member of the board can present that.
It says after which any board member may present the petition for consideration by the
Okay.
board. But it would be really good to get through with this rulemaking at some point, let me just say.
No, I think that's.
I'm not
all
saying
right.
that the points that everybody's raising are invalid points or important points, but it would be really nice to get something through. And particularly because it involves the changes to not being on paper anymore.
No, I absolutely agree with you. I think, however, making this thing clear is really important.
Yes.
All. And, you know, if the chair doesn't have that discretion, the meeting can turn into chaos. That's why it's designated that way. Okay.
Okay, so the next issue is the extension request, and the board had asked for some statistics on the extension request, and we agreed to go back to September of 2016, which is when I started as the executive director, and actually has those stats.
Yeah, so so they went back to since Ms. Balsam started as executive director in September 2016. And if you look at the chart below, there's been 29 total extension applications that have been decided, 17 of which were denied in full, 8 of which were granted in part. And when I say granted in part, that just means that they requested a certain amount of time, and Ms. Balsam gave them a reduced amount of time, and only 4 were granted in full. So the reasons for the denials included that there was only 1 extension per deadline. They were asking for additional ones, that they filed the application in an untimely manner, they failed to meet other statutory standards. And so, yeah, that's really
Thank you.
So with those statistics in mind, I think we should return to a discussion of Mr. Carver's proposal to change the extension rule. We discussed the concerns that were expressed by the board last time, and staff actually has a proposal for the board in terms of what we think it should be. And I know there was a huge discussion about should it be unlimited extensions, or 1 extension, 2 extensions, 3 extensions. So what we would be proposing would be that the executive director would have the authority to decide 2 extension requests, and if an owner needed an additional extension, the board would have to decide that request. It would have to go to, it would be presented to the board for a decision.
That's any additional extensions.
Correct, yeah. Obviously, we would have to expedite those, but we could do that. The corollary that goes along with that is, well, at this point in time, assuming everybody that was granted an extension in the past couple of years is still in compliance, there's 12 people at the moment, 12 owner entities at the moment, who could theoretically apply for another extension, because you have to apply for an extension before your current code compliance deadline expires. Everybody else's, those deadlines have already expired. So if we really want to make this work and get things moving, the other part of this would be to kind of give a one-time amnesty to allow owners to apply for extensions, even if the code compliance deadline had passed. One time, apply within 30 days of the date of the rule. After that, you would always have to apply before your code compliance deadline passed. Again, in terms of, that's just allowing them to apply. In terms of granting, nobody gets granted unless they meet the statutory standards, which are good faith efforts and circumstances beyond your control cause the fact that you couldn't comply. So that would always be in the mix. So that is our proposal.
I have a question. You had mentioned there that people apply and there's 3 separate times potentially where they could get extensions.
Right, I mean, you could apply, so there's different deadlines, right? There's different code compliance deadlines. So somebody could file an extension request and say, I want an extension by time to get a permit. And we could consider that and just grant that, and then they would have to come back and say, well, okay, I got my permit, but I still, now I need an extension of the deadline for 7B compliance. And then, so you give, let's assume that there's a reason they meet the statutory standards and we're going to grant that. Then they would have to come back a 3rd time for the C of O. And the way that we have it implemented now, we don't do it that way. They apply and we give them whatever time they would be entitled to based on the date that they applied. If they apply for all 3, we give them all 3. And most of them, most people do. They apply for whatever is left, whatever code compliance deadlines are left that they have to. And it's just easier that way. And administratively, it's a lot less paperwork. That having been said, we're not wedded to that if you're concerned about that. That shouldn't control.
So the big change here is the board would be in the mix after two consider extensions to a per plan deadline that the executive director has already put. Further, the board would have to consider for any other future requests. That's the big change here, correct? And
That and allowing people who have already have expired deadlines to be able to apply. But again, it's just an application, it doesn't mean it's going to be granted.
Is it 30 days extension?
We could
could
make it any time frame we wanted.
she was just saying.
I think a reasonable time frame is 30 days from the effective date of the rule. If you think you're entitled to another extension, even though your deadline has already passed, we're going to give you a 30-day chance, apply now, and we'll consider it. Whereas now, they wouldn't be able to apply at all. So again, if the idea is to try and get these buildings moving, that's one way, I think, to do that.
Seems like a fair package to me, what you just
It's
proposed.
accepted.
I would like to move this issue along so we can get on to other things too.
Does anyone has any comments?
I, perhaps laboring under misconception, have been looking at the protected occupant rules because I thought that was where we were going next. We had a pretty lengthy discussion on this last time, and I realized it got left with no real conclusion.
Well, the board asked for the data, so.
Yeah, and the data I find very helpful in that not only have there been a very small number of extension requests, and I gather also there are no pending requests, so it's...
Yes, at the moment, there are no pending
Right.
requests. I did have a conversation with an attorney who said he was going to file, but I haven't gotten
Yeah.
it.
So, and we had that case where the tenants agree not to object to an extension request should that owner file one or...
That doesn't, the fact that they're not going to object doesn't mean that they're not going to get, that the owner's automatically going to get an extension. I mean...
I understand, yeah, but I was saying that sometimes there's talk of doing something that then doesn't happen. So that's like a 21 or 22 month period in which we saw 29 extension requests. So I was expecting a much higher number.
You have to keep in mind that you can only apply if you're in compliance, or if you're a new owner or new on D. So the amount of buildings that can apply are probably less than 5, unless you're a new owner, new building.
And also, the way that the rule says, you can only get one, so there might have been owners that would consider applying for a second, but didn't bother because they knew they could only get one. So, all of those things would put a damper on the number of the applications. So if 3 members are in fit or want to put it on want to go forward with this, we can draft something and send it within more than 2 weeks before the next meeting if the chair at his discretion wants to put it on the calendar for September.
It's already on the agenda. You don't have
It's already on.
It's already on.
But we do have to have someone.
I'll also move.
Oh, sorry, 1 second. The 30 days, it starts from the day that they come to you.
It would be the effective date, they would have, the way that I'm envisioning it, okay, and again, we can change it, is that they would have 30 days from the effective date of the rule to file an application. And then the executive director, obviously, is going to determine whether or not they meet the statutory standards, and those extensions will be granted or denied based on that. So the amount of time that they get in the extension may vary from building to building, but the time that they have to apply for it would be 30 days from the effective date of the rule, whenever that is.
So conceivably, you're going to have many applications
We
coming
may.
at the same time.
Yes, that's correct. That's okay.
Okay.
We'll do it.
Does anyone else have any comments about this, or we can then move this along by having 3 members at least show support? Am I right?
Somebody needs a second.
Someone needs to second Mr. Carver's motion. Is that Mr.
Chuck, I feel like you're in thought about this.
Well, normally, we're looking at language when we're talking about whether to accept or not accept.
This is just a motion to move it along.
Good, yeah.
The language.
Do you want me to draft something is really, are you okay with me drafting something?
That's what we
We'll
want.
draft something.
You still
And then
gotta
you'll have the language more than 2 weeks before the meeting,
then
so that you can consider it.
Right, now I'm just trying to, as I said, I've been thinking about protected occupancy for the past month. So I can't say as I have a reaction to this at the moment.
Okay, but,
I
yeah,
don't think we need to vote on it. I think the chair would just do it.
I see the Robert's rules.
I'm in support of it.
You're in support of it?
I think I was
Is
in
there-
support of it.
Okay, that's a second, I suppose, right?
Just,
Just a second.
So are you in favor of it moving forward? So that's 3?
So wait a second.
It's done.
I just had a question between 3 and 5 on other stuff that we've been doing as we've gone through these rules. We've had the board vote a few times. And then, so,
But this is involving adding something, right? And we have a rule that says if you want to add 3 members can ask to have something added to the agenda,
right.
right? So the question that I'm raising is, do we have 3 members that want this added for consideration for the agenda?
Not a rule yet. Still
Not
gotta
a
get to
rule.
it. We're gonna
I
get
know
to
that.
it.
That's my next question, but we'll get to that after this.
All right, so
So
then,
the answer is
so then the
yes.
answer then is yes, it's to be added to the agenda, and the staff will prepare a draft rule for September, and they will send it out at least 2 weeks prior to September's meeting, at which point staff will have a chance, the board will have a chance to debate this rule. There's nothing binding until the board takes a vote of the rule, or until the rule is voted on final. All right,
Okay.
thank you.
So yeah.
You want us to go on?
You want to start?
No, actually, what I want to do at this point is question, no, this is very serious. I, over the last month, kind of separated all this material, and we had in 2017 what I now call Chapter 2 of 2017. We had a much broader proposal for Chapter 2 modifications to the rules that now appears to be shelved. The work we started to do on Chapter 1 is now joined by what I'm calling Chapter 2 of 2018, which is a much slimmer collection of ideas. In the middle, we also had what I think of as the de Blasio suggestions, which were drafted and then kind of fell by the wayside in the latter part of 2017. We're now, and part of the reason with Mr. Carver's concern about how does the board get things done, clearly a lot of time over the past 18 months has been taken up with consideration and drafting and dealing with rules. And in fact, the rules seem to be of such urgency that there were several months where we had 2 meetings. Now we're about to take a 2-month break to come back to further consider these, which after I guess we're going to end up with a body of the Chapter 1 stuff that's survived all this time, the new, somewhat more abridged version of Chapter 2. It still has to be finally voted out by the board, to then go to the law department and the mayor's plain English police, or whatever they're called, to come back for us to then publish, and then there would be a hearing. So by this point, it seems to me, it's winter and it's 2019 and there's snow outside, And we'll almost have a new group of interns before we get anywhere. And last month, a rather significant question came up that has yet to be addressed about the retroactivity in the application.
You are doing the research, but we haven't finished it yet.
So I'm
It's becoming cynical.
becoming cynical? No, I'm just kind of thinking it might make sense for us to see if we even really understand what we're doing here.
I think we do. I think we do. It's the debates that slow things down, right? So, listen, if board members are amenable to this, let's have an extra meeting again, extra meeting for September, so we can discuss the protect document rule, but maybe even before or after the regular scheduled meeting, so we can move things along. We want to move things along.
And our 2-week rule doesn't work, so.
No, the protected occupant rule is, there's a draft of it.
It's a draft
We
already.
already have that.
Oh,
So
I just mean for adding to the agenda. If we meet 1 week and then 2 weeks later.
No, that's why it would be just to discuss
protected,
protected occupant section.
Only that.
Yes,
Oh.
which probably is going to be.
That would be good, because I could already prepare for that if that's what, we know what it is.
So, I mean, we do want to move things. I mean, it's frustrating too, but, you know, you want to grant people an opportunity to, I mean, not that I have a choice, people, you know, you have to debate, but we want to be as free as possible in granting members an opportunity to discuss these rules and to debate them, so we have a better set of rules. Yes, Mr. Bishop.
Just to kind of go on the record with my thoughts that support some of what different folks have said, with the exception of August, which I already understand we're not going to have any meetings. And I think I have said before, so I'll just clarify it again for the record. I think we need to have 2 meetings a month until we get this thing put to bed. And stick to that, because I think Mr. Delaney brings up some valid points, and you know, I know from my own standpoint, too much of a lapse in between, and you know,
I think it's important enough to do that, yes, thank you.
I don't think we should do that. On the other hand, it's very important that somehow we reach consensus on these things and not constantly debating. And we've been over some of these rules already, and it keeps coming back and bugging all of us.
But I sort of feel, Elliot, that if we stick to this rule and stop with some of the gaps and keep it fresh in our mind, that I feel we can push through some of those walls.
I hope so.
You know, I might be wrong, but
I see 3 things left to discuss. This extension thing that just came up, the protected occupancy rule, and the part about the penalties. I don't think that the penalties will be very controversial. I think protected occupancy will be very controversial. I think we've kind of reached consensus on the extension, maybe. So after that, there's a few like housekeeping issues to go back and talk about. But I think we're close. Much closer than we've been since the beginning. So I really am.
Okay.
So it seems just in addition to that list, I'm not clear, and I meant to go back and reread the May minutes, but I didn't have the time to do it in the past week. I think there are still some open questions on the narrative statement conference section as well. I asked staff about the cutoff at 50 for the expanded period.
Okay, we can go back to that. I thought we had actually decided that, but okay, I'll go back and reread it, just to make sure.
So in September, you'll also, it sounds like staff will have information on,
Yeah, so I don't agree with that.
Information on what?
Go ahead, finish your question, because I thought.
Now I'm distracted on whether, what were you researching? You were researching on?
Whether or not the rules
how
can be
they
applied retroactively.
Right.
Yeah, yeah. So we are researching that. It looks like the answer is no, but I want to make sure before I say that definitive.
So you'll have that prior to our September meeting?
Yes, particularly because an intern is doing that research and she's leaving and she'll have it before she leaves.
Okay.
Or she'll come back.
She doesn't have to go back to school.
Okay.
Thank you. This concludes our July 19th, 2018 Loft Board meeting. Our next public meeting will be held here at 22 Reed Street, first floor, September 20th, 22 p.m. I'm sorry, we may schedule another meeting, so I think maybe after 20th.
I think the Jewish holidays are early this year. I don't remember.
They're early,
Yeah, so.
Okay, so this would be after the 20th.
I'll send an email around to everybody asking for dates.
So the next meeting is September 20th, 2018 at 2 p.m. Board members, please sign and hand in the attendance sheets. Thank you.